All right, so this is an introduction to the judicial branch. We're going to get into the court system and how it is written in the Constitution and where it's gone since. Then I'm going to direct you to some other materials to help get your study of the judicial branch started. On the screen, you see the beautiful Supreme Court building that was modeled after actually the Acropolis in Athens, Greece. And above it, etched in the stone, it says equality under the law. The other thing is that you'll see a photograph of uh, the nine Supreme Court justices as they are today. And you'll see that the Supreme Court in the middle of the front row is the current Chief Justice. His name is John Roberts, and he was appointed by George W. Bush. Having said all that, let's get out some paper and a pencil and let's get going. The first thing I want to just bring you back to is the whole concept of separation of powers and just have you recall that we have three branches of government that basically have three central jobs. And obviously there are some other things that these branches do, but they sort of all fit under the umbrella of this. The legislative branch's job is to write laws. The executive branch's job is to enforce laws, to make sure that those laws are followed and to outline how they're going to make sure they're followed. And lastly, the judicial branch, which is the court system, is there to interpret laws. And I break this down by explaining that there's two ways how to interpret law. And the first way is to determine if an individual has broken the law and to what extent. So you hear about people being pressed with charges, for example, let's say second-degree murder. That is going to go in front of a court, and a jury is going to decide if, in fact, that individual has broken the law and to what extent and how they should be punished. The second way is that the court system is there to also determine if laws that have been written by governments, whether they're local, state, or federal, have violated the US Constitution, or if they're violating your personal liberties and rights as outlined in the Constitution. And we'll talk about in a moment how those liberties were actually not even in the original Constitution, but yet had to be added 2 years after its ratification. So, this is some text from Article 3 of the Constitution that is probably the most important for our purposes of how the Constitution outlines the court system. In some of the videos that I've provided for you, you will hear an overview of sections 2 and 3 of Article 3 that outline the types of cases that a Supreme Court shall hear, and then also the way in which other cases would be heard. So, Section 1 says the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, as stated times, receive for their services a compensation, which shall not be diminished during their continuance in office. Let's break this section down a little bit. So I've bolded a couple of phrases that are pretty important. And the first one is one Supreme Court. This is the only specific court that is mentioned in the Constitution. And it's really important to note that because this section of the Constitution is actually pretty vague. And it's sort of vague on purpose. It's vague because they're giving Congress a lot of power over how many courts the country will have. You'll notice that in the next section, it says, as Congress may from time to time ordain and establish. This is an example of checks and balances. The Congress's ability to check and balance the judiciary. So, by being able to create or abolish lower courts, this gives Congress, in my opinion, a lot of power. And of course, any law that establishes a new court would have to be signed by a president. So the president is sort of involved in this process as well. We haven't had new courts created in a long time. There have been a few acts of legislation that have drastically changed the court system. And the big one is in 1789, the year the Constitution was ratified. The other thing that's important to note here about the Supreme Court being one There was no court system at the federal level under the Articles of Confederation. There was no central U.S. national court that could settle disputes between states. There was nobody that could determine if the state of Rhode Island passed a law that violated your freedoms or violated the articles. There was nothing like that. So, as a result of that weakness of the Articles of Confederation, we see this written in plain text in the Constitution, and for good reason. The next piece is about how judges shall hold their offices during good behavior. This is another way of saying judges have lifetime appointments. When we read the Constitution for Congress and for the executive branch, we saw that they gave those positions term limits. Reps 2 years, senators 6 years, presidents 4 years. There is no limit for a judge. Why is that? The reason why is because they wanted judges to be completely impartial. And how do you get a human being to be impartial? Well, I bet many people would argue that it's impossible, that everybody brings in their own intrinsic bias into making decisions. But what we can do with lifetime appointments is this: we can eliminate the possibility of electoral politics, meaning trying to win an election, influence the decisions of a federal judge. And that's pretty important. You may wonder, has anybody ever been impeached? There was one justice, Samuel Chase, in 1805. The impeachment process started in 1804 and was finished in 1805. He was a pretty hardcore Federalist, and the anti-Federalists at the time that were controlling the Congress didn't really like his rhetoric and his the way he approached questioning during the Supreme Court hearings, and they impeached him on 8 different counts. And I don't have those in front of me right now, but I'm sure you could look them up. The Senate acquitted him, and he was not removed from the bench, and he served for a long time. So there's one person who's been impeached on the Supreme Court. So going back to what you just saw in the Constitution, there was nothing in the original document that protected your personal liberties as an individual, and that was a problem. The whole point of our new government was to protect people from a tyrannical government. So there was nothing in the document that did that. So, in order to ratify the Constitution, a promise was made by the framers of the Constitution, in particular to states like Rhode Island. Rhode Island actually basically said to the Continental Congress, the people that, ratifying the Constitution, we are not going to accept this document unless there's a Bill of Rights. And the people who wrote the Constitution were tired. It was a long summer. They said, yeah, we got to go home. We know that. We know it's a problem. We're going to add it. Just ratify what we have so far, and then we'll add it. So the first 10 amendments were passed in one shot, the Bill of Rights, and the Bill of Rights is the antidote to this problem, that there was nothing in the Constitution protecting our liberties. So if you go back to that idea of the judicial system determining if laws violate your rights, before the Bill of Rights, what would that mean? What rights are being protected? After the Bill of Rights, we actually have a list of things that are protected by the United States Constitution for us as individuals. So I'm not going to talk anymore about the Bill of Rights right now, because I'm going to give you another thing to take a look at in a moment, which I think does a really nice job of outlining those 10 rights to us. But hold that thought for a moment. This is the current Supreme Court. You'll notice this little graphic was from the fall of 2019. We have had no changes on the court since then. You can pause it here in a moment if you want to just take in who the presidents were who appointed these individuals. You'll notice that the oldest appointee comes from the Bush presidency, the H.W. Bush presidency in 1991, and all of these individuals on the court have been appointed since. Some recent vacancies on the court that resulted in Neil Gorsuch and Brett Kavanaugh's appointment by President Trump were due to death and resignation. So Antonin Scalia passed away, and then also Brett Kavanaugh was appointed because Justice Kennedy retired. The court system is a dual court system, meaning that there's two coexisting systems in the country. Because we have a federal system, federalism structure in the United States, it only makes sense that if one breaks a state law, their case would be heard in a state court. And if one breaks a federal law, their case would be heard in a federal court. And the map on the right is a district map of the United States showing you how by population we've divvied up the country to make 12 pretty equal in size in terms of population districts. The Judiciary Act of 1789 made the court system very large. And what it did was break the court system into a series of two different levels of courts. One are just your regular courts where states and local cases would go or federal cases would go. Then there's some special courts over here, courts of international trade, courts of claims, tax courts are included in that, and then military has their own court system. Then there are what we call appeals courts. So I don't have a lot of personal interaction with the court system, but I have seen it in a lot of TV shows and movies. People talk about appealing a decision. And what that means is if I had a case in the federal district court, district number 1, because I live in Rhode Island, if I was unhappy with the result, I could appeal my decision to the Federal Court of Appeals. And if I was still unhappy with that decision, I could appeal it to the Supreme Court. The Supreme Court of the United States gets to choose which cases they hear. You're going to hear more about that in another video. This is another diagram showing how the Supreme Court is the highest level of court in the country, and that all cases below it, whether they're local and state or federal or they're special, can be heard by the Supreme Court and they will have the final say. Ultimately, it's totally up to the discretion of the 9 justices on the Supreme Court. At least 4 justices have to agree to hear a case. And therefore, if that doesn't happen, the case's decision in the prior level will stand. The next 2 videos that you're going to check out are both under 5 minutes long. One is about how cases get to the Supreme Court, and it has a lot of cool statistics about the number of cases or examples of types of cases that go to the Supreme Court, including the 2000 election between Al Gore and George Bush. And then the second video is about the Bill of Rights. And I would take a piece of paper on this one and write the numbers 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And write down what those Bill of Rights are, the first 10 amendments. There are links to these videos on Google Classroom. Have some paper handy. Again, total, you've got under 10 minutes of video here. You might pause a couple times to write a few things down. Thank you so much.